presenting the current debate about liability for AI, but I hope it will become clear in a moment, because there are several connections with the debate about rights to data, be them exclusivity or access rights. As you already mentioned, Florence, there's quite a great and now for several years ongoing legal debate about AI, and I took the liberty to show some of the main papers. After that, I will talk very briefly about the technical background. Basically, I will just try to outline what, in my opinion, are the key features of AI, which makes AI special from a liability law point of view. And then we will have a look at existing liability regimes, which do apply to AI just as well. But there is still the question whether we do need some additional legislation. And in order to discuss that, I will turn to the functions of liability regimes, meaning what is especially the economic function of existing or maybe additional liability regimes, and then turn to the key question, in my point, the key question even in the current political debate: who should be held liable, not only under existing liability regimes, but especially who should be held liable under potential new liability regimes. And a very brief outlook to one last point: there are some connections between liability and intellectual property in general, and these connections might be important for the debate about data and liability for AI as well. But let's turn to the current legal debate. Actually, these slides are outdated already. Why so? Because last week, I think last Tuesday, the European Parliament adopted a resolution, especially on the question of liability for AI. The resolution with recommendations to the Commission on a civil liability regime for artificial intelligence, 2020/2014. And so I will try to touch on some of the points that were raised there. The interesting thing is that right now we do have an actual legislative proposal on the table, and we will probably have time to discuss that after the presentation. And it will become clear that I do think that the proposal is a good thing, but I'm not 100% in conformity with the proposal as it stands by the European Parliament. The paper preceding this proposal is the European Commission white paper, also of 2020, with not a concrete legislative proposal, but some details about potential liability regimes for the future and existing liability regimes. And it was combined with a report on the safety and liability implications of artificial intelligence. So basically a detailed, in-depth analysis of the existing legislative environment, so to speak. And there were a lot of preceding papers. Florence, you already mentioned we had this quite important high-level expert group report on ethics guidelines for trustworthy AI. And most of you will know this paper because it outlined 7 features which, in the eyes of the Commission, are necessary or should be prerequisites for trustworthy AI. Among the 7 features, there is human agency and oversight. There is transparency, which is also quite an important issue for liability law. And there is accountability, explicitly including redress, meaning accountability also in the form of legal liability to a certain extent. But it will become clear in a minute, I hope, when I explain to you the functions of the existing liability laws, that accountability does not mean that you should be held liable under all circumstances, but we need a well-functioning liability regime. We have a report from the expert group on liability and new technologies. There are two subdivisions. One is the new technologies formation. They have furnished a report with very detailed ideas about potential liability rules, new liability rules, including, I come back to that, a definition or a distinction between back-end and front-end operators of AI. And there is another subdivision. It's the product liability subdivision. They have, I'm part of this subdivision. They have not delivered a report so far. And the reason for that might be that the existing product liability, and I will touch upon that in a minute, applies to a large extent, of course, also to AI and provides solutions to many questions. But the debate whether this whether the existing product liability directive should be amended or not is not yet resolved. There is in the resolution by the European Parliament and the legislative proposal therein, you could say they try their utmost to let the product liability directive stand as it is and only change it in very small amounts. I come back to that in a minute. And there are even older papers, so to say, which I will not go in further detail. Interestingly enough, there's a paper which is a study which was carried out for the European Commission by Deloitte, which already in 2017 tried to look at all the different sectors, economic sectors, where AI might play a role, and they touched upon the topic of data markets and on the topic of liability for AI in connection. And that is arguably the main point of my present talk, to show you that you have to see these different legal problems in connection. What is the technical background anyway? Yesterday, you have learned a lot about the connection also between AI and the data market, and I come back to that in a moment. If we look at AI as such, arguably there are three main drivers or technological drivers, developments in the last years that might force the legislator to take action. The first one is robotics, meaning you have a direct coupling between software and hardware, which implies a potential to cause damages in the physical world by glitches, so to say, in the software area. And that's something not completely new, but with the rollout of robotics in more and more areas of everyday life, we have a kind of new quantity and therefore also new quality with robotics. The other area is connectivity, meaning that computers, machines are more and more connected. This is discussed in the industrial area as Industry 4.0. Or in a wider sense as the Internet of Things. And to a certain part, this is a thing of the future. But we will see increasing connectivity, which of course is a great challenge to liability law, because any connection can mean a new path of causality. The key feature that is currently discussed as AI is machine learning. And sometimes you read or you see the phrase autonomy, which is a very multifaceted term. So I'm careful with the term autonomy and to distinguish it from automation. But from a technical point of view, machine learning is something new, meaning you have a shift away from mere programming of computers and robots, where the programmer has to have in mind the whole potential areas or a room space of behavior. You have a shift from that programming to training. So the programmer no longer has to think about all possibilities, but can create a machine which is able to learn itself using, and there is our current debate, using, of course, data, large sets of data. And that is what makes the data market so important, because the rise of machine learning means the rise of data markets. We have a quite similar list of technical issues, so to speak, in the report on the safety and liability implications of artificial intelligence, the report that was combined with the European Commission's White Book. And among the features that challenge the legislator, they explicitly list connectivity, autonomy, and data dependency, which I would combine with autonomy. Opacity, I come back to that in a minute. Transparency problems with certain some machine learning aspects, especially the neural networks, and complexity of products as well as complex value chain. Complexity of products, I would say, is nothing really new. We have complexity in standard software products as well. So you can see the list is similar, but not completely identical, but at least autonomy and connectivity are seen to be major challenges. That brings me to the main theme of my presentation, and that's the connection with data and the question of actors. What do I mean? We can, if we simplify very much what we discussed yesterday and what we're discussing today, we have a kind of new value chains where machine learning or the ability of learning plays the role that we have a value chain where untrained AI has to be trained. You have a trainer there, and then trained AI may be used to derive some results. That's a key challenge for intellectual property lawyer, not for us today. But we have here several different actors in the loop. And what makes it interesting for us in the context of data markets, we have providers of data which are used for the training. So we have also an actor here, or actors, maybe many actors, providing data. And we have a source for damages here with the providing of data. And of course, then the question of maybe such data providers should be held liable. From a classical liability law point of view, you would distinguish between manufacturers on the one hand and users on the other hand. So this comes from product liability perspective, but applies to many liability questions related to machines, products, maybe software. I come back to that in a minute. That you have a classical value chain where a developer and producer puts something on the market, which is then operated and used, and then may in the end cause some damages. And of course, along this value chain, the question remains, who should be held liable if anything happens? And the key message in the use of IT in general is that the user and private or consumer operators have less and less influence on the safety of the machines they run. Whereas the producer has an increasing influence. And now with the rise of autonomy, we have on the producer side programmers as well as trainers, and the two might be distinct. That makes it more complicated. So this is just to show you the landscape where the whole debate is situated. Now let's have a quite short look at existing liability regimes. As you all know, we do have negligence liability regimes which rely on a breach of duty which has to cause a damage. So the main feature of any negligence regime is that you have to prove that a breach of duty has happened, that negligence has taken place. And of course, if you are able to show that maybe even the provision of data was done in a negligent way and that this caused a damage, then even under the existing liability regimes, you can be held liable. Question is, can you prove it? And that brings me back to this three different technological aspects with increasing connectivity, with increasing amount of data, and with increasingly complicated machine learning, which is, in the case of neural networks, of deep learning, to a certain degree intransparent, you may no longer be able to prove breach of duty and causation. We do also have product liability, which is harmonized in Europe under the Product Liability Directive, and I will come to that in a minute in the next slide. We do not have yet strict liability regimes for the specific production or operation of AI, and that's the main focus of the current legislative debate, whether we should introduce strict liability regimes for AI or not. And as you may guess from what I have just said the slide before, the key question is who should be held liable under such a strict liability regime? Should it be the producer or should it be the operator? You may argue that the product liability is a strict liability. I will show you in a minute that it is not, because it requires a defect. I may also add that in the current legislative proposal by the European Parliament and even the proposal by the expert group, there is the idea of a strict liability of the operator. And just to make my key point at that early stage, I think a strict liability of the operator does not make sense as such. It only makes sense, it's only economically sensible in as far as the operator still can control the risk. But if you have an operator who just may switch on the AI and off and nothing else, then a strict liability may be problematic. I have already mentioned that you may differentiate between back-end and front-end operator. De facto, the back-end operator is a producer, and in the end, you have something like a strict liability for the producer, which makes sense as long as the producer is the risk controller. I will not touch upon the very tricky subject of liability for agents, which we have not harmonized in Europe so far, the respondeat superior rule. There is quite some debate whether we should apply such rules to AI, especially if you combine it with the idea of e-person. I personally argue that this is an unnecessary complication, and it does not make much sense as long as you establish safeguards that an artificial intelligence has funds, money of their own, and in the end, to safeguard against damages or to have a proper liability regime, it's simply unnecessary. But we may discuss that later. Let me talk briefly about the product liability. I already mentioned that there is the report from the expert group on liability and new technologies, and there are several issues raised. The most important one is an old one, whether software can be seen as a product. As most of you will know, the existing product liability directive only focuses on physical goods plus electricity, but other immaterial goods are not included. But there seems to be a growing consent that at least software should be included explicitly, so to make the manufacturer of a piece, so to speak, of software also liable under the Product Liability Directive. The next thing is the question whether defects caused by learning are encompassed or not. This can be solved quite easily if you argue that creating a machine which is able to learn, but to do it without proper restrictions, is creating a defective machine in the first place. So arguably, defects caused by learning are easily encompassed even under the existing product liability regime. The more problematic question is whether you should or we should introduce a real strict liability, meaning a liability which does not require any defect for certain high-risk products, products with increased risk of harm. We do not have that so far. The proposal by the European Parliament tries to solve it by reversing the burden of proof for high-risk machines, such as special areas or special AI in certain sectors with a high risk. I do not know whether that is enough. In a minute, I will show you why strict liability as such might be a good thing and not only detrimental for further development. There are some other things discussed, like logging features, which is, of course, combined with the question of reversal of burden of proof. These are the main topics discussed right now, and we will see whether the Commission comes up with a detailed legislative proposal on how to amend the Product Liability Directive. I have talked so much about the functions of liability, and now let me explain what I mean. There is a huge difference between liability for negligence and strict liability as regards the effects, the public policy effects of such a liability. Whereas negligence basically controls the level of care, meaning that parties who potentially are held liable are just striving to reach the exact amount of care which is necessary not to be held liable and nothing more. With strict liability, you have a different incentive effect, not only for maximum level of care, but in addition for the activity level. Meaning any activity which is combined with a strict liability has to be judged in advance by the parties potentially liable, whether it is worth it or not. You have, economically speaking, a complete internalization of the risks. And this has, so to speak, the beauty that you can activate any risk knowledge of the parties involved, which probably other parties, and especially the state or judges who have to ascertain the level of care, do not have. So strict liability is the perfect regime for new technologies like AI, because it enables the legislator to kind of sit back and say, okay, the parties who could be liable, they have to judge whether a certain technology should be rolled out or not, or whether it should be improved and rolled out at a later stage in a more safe version. There is also the argument that you have increased public acceptance with such strict liability regimes, but of course you can also have public acceptance with strict social insurance regimes, or even strict liability combined with a third-party insurance, meaning compulsory insurance, which then rather has the function of socializing the risk than giving incentives. One last point, the classical liability for negligence has also the quite important feature that as long as the necessary level of care is reached, potential damages are borne by the injured persons. So the injured person in the end is the one who sits on the damage. And this is an incentive in its own right, but this of course makes only sense as long as potentially injured persons are able to avoid the damage. Like in the case of, let's say, traffic, we have in Germany, not in all European states, we have a strict liability for operating a car, but not for operating a, let's say, a bicycle, because it's easier to avoid bicycle accidents. And admittedly, the main idea of the strict liability for cars is that it is combined with a third-party insurance obligatory, and that you have a socialization of the damages among the group of car users. But the key problem is, if we only have liability for negligence, and if the level of care, the necessary care, is set at a low level, in the end, we have a kind of incentive for innovation at the cost of the people who might be injured. Arguably, legal historians said that this is exactly what happens in early industrialization, but that probably is no longer the proper way to do it when it comes to new technologies nowadays, like AI. So you can see I'm quite a fan of strict liability, and I think it does not stifle development. It rather is an incentive for further development, and it is an instrument for internalizing risks in an economically sensible way. But the thing is, the key question is who should be held liable, and the thing is, it only makes sense if the potentially liable person is the one who can control the risk at all, either by developing properly, programming or training properly the AI, or even by developing it further in order to obtain a safer AI. If you have no risk control, strict liability doesn't make any sense apart from the idea of socialization. So risk attribution should follow risk control, and that makes it so problematic if we have proposals saying that the front-end operator should be held liable. You only could argue if you have compulsory obligation insurance schemes that maybe then you have a kind of socialization of AI risks among AI operators. Arguably, I would say rather it makes more sense to hold the producers, the programmers plus the trainers liable, not so much the front-end operators, and definitely not the users. You have a famous saying that with the special case of autonomous cars, the driver becomes a passenger. That, I think, shows it pretty clear why these persons should rather be held not liable at all. You can even argue that the simple use of AI should, under normal circumstances, not constitute negligent behavior unless you use it intentionally to cause a damage. And that brings me back to this question: where is the data market here? So far, no one really argued for liability for the providers of data, and probably that is a good thing, because we have here, with the programmer and with the trainer choosing the data, we have persons who are better in charge, so to speak, to control the risk and who might be held liable. One last point. I've already mentioned there is also a connection between liability and intellectual property, which should not be overlooked. But this is rather about intellectual property in AI, in trained AI, and maybe even in AI-generated products, not so much about IP in the data. I think if we talk about data, access rights are perfectly right. But just let me mention this last point. There is a parallel between risk allocation and opportunity allocation. And if intellectual property right is all about allocating the benefits, the potential benefits, then liability is all about allocating the risks, the potential damages. And to have a full internalization, meaning the right incentives, you should internalize both of them. And this is a strong argument to create liability regimes in parallel with IP regimes if it comes to IP in the AI itself. And there's one last argument. I already mentioned there's a huge debate about transparency of AI. And it could, in one point, happen that we have transparency obligations, but might balance them with intellectual property right-like exclusivity for the use of certain trained AI. And this is what we already discussed in the case of clinical data. And we have it in several areas, that wherever a transparency obligation crops up, IP rights, IP-mediated exclusivity might be a proper instrument to balance these transparency obligations. But this is only a very mature, early thought, not directly related to the debate about data markets. And with that, I'm at the end of my presentation. I'm looking forward to the discussion. Thank you very much.